So welcome to the second talk of the Nova Consumer Talks. Thank you very much for being here, and thank you especially to our guests today. To Martim, he's not a guest; he's part of our research team, and Przemysław. And it's not always easy to pronounce your name. I hope to and then it well again, as in the last talk that you participate. And to Vanessa, my friend and co-editor at the European Journal of Consumer and Market Law. It's really a great pleasure to have you both here today at the Nova Consumer Lab and at the Nova School of Law in Lisbon. It's at distance, but it's what makes this possible, and makes it easier to participate in those meetings. So the pandemic crisis that we are living, which is really terrible in so many things, but it brings us together in more occasions than in previous times. So thank you so much. The idea is for this talk to last for 1 hour maximum. So you are not here to hear me. So I will give the floor to Przemysław, who is starting. Is that it? Okay. No, Martim.
No, I'll start, and Martim will go second, if that's fine.
Great. Thank you so much. Thanks again for being here. I didn't present you. Przemysław is associate research scholar at the Yale Law School and visiting fellow at the Information Society Project at Yale. I think it's correct. So it's a great pleasure. Now he's in Poland, I think, but usually at Yale Law School in the US. And we are on the news right now because of the elections without a result. It's not what we are going to discuss here today. So virtual goods and European consumer law. Thank you very much again for being here.
Thank you very much. Thank you for the invitation. Thank you for organizing. Thank you to Vanessa already in advance for your time and comments. It's a great pleasure to be here and to talk with you about a subject close to my heart, namely virtual goods and European consumer law. The question I want to address today is, what is the legal status of virtual goods in European economic law, particularly consumer law, and sort of what are the rights and duties of various parties there, and how we should look at that in the context of existing law, but also potential law reform. And to begin, as I assume not everybody on the call is familiar with the concept of virtual goods, I wanted to start with an example. And here you can see a screenshot from a game called Clash of Clans. And in this game, a player is supposed to build a village. To build a village, you need some virtual gold. In the top right corner of the screen, you can see that the player now has about 10,000 pieces of virtual coins, and you need to wait some time. Here you can notice that it's 3 hours, 51 minutes of real world time that will pass before this particular construction is ready. However, the further you get into the game, the longer the wait is. Here you can see that my barracks will be ready in 5 days, 11 hours. It's a long time, and sort of the game is less fun when you need to wait. However, as you can notice on the bottom of the screen, you can also have the construction ready, finished now, if you spend 814 gems. Now, where do you get these gems from? You need to go to the shop. There is an icon in the right bottom of the screen. And in the shop, you see the option of buying those gems for real world money. So the game runs on this so-called freemium model. It's free to play. You don't have to pay money for it. But if you want, you can buy something for real money. Here, for example, 500 gems for $4.99. If you click that, you will be asked if you want to confirm this in-app purchase. You see a price, and if you confirm that, those gems will appear on your account and money will go off your credit card. There are also some commercial practices, advertisements every now and then. Here you can see a screen when the player is informed that there is a special offer, there's some great value, it's time constrained, there's a countdown clock. And so the question is, what legally speaking happens once the user purchases such virtual goods, namely buys something that sort of exists within the game for real world money? On the first side, it would seem from the phrasing that we're dealing with something akin to a contract of sale. There is a shop that you enter, there is a purchase that is happening, there is a price that you have to pay, there is a virtual good that you acquire. And the setting, which we can see here, is something similar to, those are definitely commercial practices, potentially unfair commercial practices. But the question in the end is the legal puzzle. Is it a contract of sale really, or what is it precisely? And to know that, we need to go to the umbrella agreement, terms of service, which the user always accepts when starting an account here. Even if you don't play games, you're familiar with the concept of terms of service. Facebook, Amazon, everybody else has them. And in here, you will see that in the service, you have a right to purchase a license to use virtual goods. However, it's a limited revocable license, and Supercell, who is the provider of the game, may manage, regulate, control, modify, or eliminate virtual goods at any time, with or without notice. And Supercell shall have no liability to you whatsoever. What we're dealing with here is a new kind of power imbalance that exists between traders and consumers, which on top of every other imbalance, which is market power, knowledge about the product, unilateral drafting of contract, etc., is a factual ability to unilaterally control, modify, eliminate everything within their service. And that ability is something which in my scholarship I label digital force. If you want to compare this to a real world situation, imagine that you go to a brick and mortar store and buy a pen which writes in blue. Let's say it's important for you that it writes in blue. And imagine that the seller has ability, is factually able to, on distance, change suddenly the color in which this pen writes from blue to pink, or just make it disappear. Would we label this contract of sale? Probably not, probably something else, but there is this ability which in the real world simply doesn't exist, so we never had to think about it. And on top of this factual ability, the providers claim to have a right in the contracts that they draft to unilaterally do so. At this point, you might be wondering, okay, this maybe is interesting, but like, who really cares about games? Why are we talking about games if we could be talking about much more serious consumer issues? And I would say that that is a fair criticism, but there are two reasons why I think this is actually a very important problem. First of all, in itself, video games and mobile games as part of that at a huge entertainment market, which in 2019 was worth $68.5 billion, which is more than music industry and film industry, which are so-called established and respectable entertainment sectors combined. Supercell, the creator of Clash of Clans, made $1.5 billion last year. So it's a market worth a lot of money, and it's a market, because it's a gaming market, that is prone to consumer harm and consumer abuse in many areas. On one hand, we're dealing with the problem of addiction to consumer games. Those services are often created in a way that are supposed to hook players onto playing more and more. You might have heard of the concept of gamification. It comes precisely from video game developers who sort of know how to make game make you feel good or bad about yourself and spend as much time there as possible. And second of all, there is a potential for consumer abuse with all those micro purchases. The way it usually works is you start playing a game, you start enjoying it. At the beginning, you don't need to pay anything, and suddenly you need to wait one day before you can do anything else. You don't have to pay, but you may be more prone to do it if in case that's where you find fun. And so the way it's structured, the way it's delivered is, I think, a serious consideration for consumer protection lawyers. So I would argue that this is important in itself, but it's also important as an illustration of the structure of power in the internet that is built around platforms. Internet did not have to be built around platforms like Facebook, like Amazon, but it ended up being so. There are attempts now to sort of break it up through interoperability rules, through more antitrust enforcement, but as of today, it is. And I would argue that the essence of the power imbalance here boils down precisely to the fact that providers of online services have factual ability to control everything that is happening within that service, right? Facebook is able to delete your post or ban your account. Amazon is able to delist something that you're trying to sell. They're able to sort of influence when and where your posts or listings will appear in someone's searches or timelines, and any other app that allows you to purchase something inside, like Viber, which is a communication platform, or Tinder, which allows you to also buy some perks, works in the same way. There's an in-app purchase in a service that is free, which, however, can disappear if only the service provider exercises their factual ability to either change it, modify it into something else, or to simply make it go away. And so this leads us to the question on what are the legal limits on the use of digital force. If there is this factual ability for the provider to unilaterally do something with the goods, what are the checks on the exercise of that power? And there are three general possibilities. One is regulation, that is certain limitations allowed, certain limitations on allowed market conduct. There can be law that simply says you can't do something. And the other two stem from, say, more traditional private law, and that is contract, how the parties agree on what their rights and duties are, or in case of standardized contracts, regulation of unfair terms in contractual setting, and property, namely questions about new or already maybe existing erga omnes rights in virtual items. An example of regulation that comes to mind here is the unfair commercial practices regulation, directive, that is the source of rules in the European Union, which includes prohibition of commercial practices that materially distort or are likely to distort the economic behavior with regard to the product of the average consumer in a particular market. This regulation is important, especially in the area of games and places where those companies usually make money by addicting users to spending as much time as possible within a service and tricking them into buying things when they feel like they need to. And this leads to sort of, on one hand, addiction, on the other, abuse of users, which are called so-called whales. This means that most people who play those games won't pay, but those who will pay a lot of money. So there is some tool, there are some tools in European law already now, but unfair commercial practices does not address the problem of deletion, modification of content. It's not a check on the deployment of digital force. Then we get to the question of contract law. Here, the directive on unfair contractual terms, which renders terms that cause significant imbalance in parties' rights and obligations to the detriment of consumers not enforceable. And this term, which I showed you, would probably be such a term, right? Like where the provider can unilaterally, with no reason, no compensation, delete an item, maybe it would be unfair. But this gets us immediately to the question, if such a term is unfair, meaning it cannot be enforced, if I go to court and we agree that, okay, this term will not be enforced, what is the default rule on who is entitled to what? Is it does it mean that I'm entitled to keep my virtual items, or does it mean that the provider has a right to delete a virtual item nevertheless? And this boils down to the question of property. Is there anyone who is prima facie entitled to having their virtual goods undisturbed or to do with them as they pleases? And it's by no means clear to me that it is the user that enjoys any right here. Why? Well, we need to understand that virtual goods are not really goods in the way in which private law would traditionally think about them. We traditionally distinguish between material goods, which are made of atoms, and immaterial goods, which are social constructs. Immaterial goods tend to be explained as residual categories, where everything that is not material falls. But the problem with digital goods is that even though they're not material, they're not social constructs. If I disagree with someone's right to do something, it does not disappear. But if I want to make someone's virtual item disappear as a provider, it can happen. And virtual goods, and here comes the definition, which traditionally probably we should come at the beginning of my presentation, but I want to start with an example and sort of explanation of what the issues are, is a subclass of digital goods encompassing those which necessarily exist solely without a particular service. So if you think of other digital goods as an ebook or a movie or a song, they can function as part of Amazon Kindle or any other provider. But Clash of Clans games make sense only inside Clash of Clans. If the game is off, the games not only no longer exist, but it doesn't even make sense to try to conceptualize them outside of this particular setting. And private law is traditionally silent about the existence of digital goods. The Digital Content Directive created a all-encompassing definition of digital content defined as data which are produced and supplied in digital form, which maybe from consumer protection point of view sometimes makes sense, but from the conceptual point of view does not really get us far. It's as if we try to build contract or property law around the notion of stuff, right? Without distinguishing between movables, immovables, etc. And so there is this one last question, which is there property in virtual items after an in-app purchase? This obviously is a question that might be answered differently under different national private law regimes, because property is not a competence of European Union. But when we think of regulation and sort of the lega ferenda questions, it is by no means clear that this type of intervention, namely granting users default property rights and items they purchase, is a smart way to go. One, because at some point those services will be turned off. There is a question of whether turning off a service would violate someone's property right. Also, there are many legitimate moments when providers might want to delete items of someone who either is a bot or is abusing their service. Would that be violation of property? Then there are moments when they update or patch the code that might influence the functioning of virtual goods. So property might seem like a good solution, but it gets pretty complicated pretty fast. But I would still argue that even if we don't want to grant property rights from the regulatory point of view, it still makes sense to sort of try to get the better classification of digital and virtual goods as a part of regulatory structure. So to conclude, virtual goods exemplify a new type of power imbalance between users and providers of online service, namely digital force, the ability to unilaterally modify or delete content within the service. They exist in a conceptual void, and we do need a better classification of them. And regulation-wise, even if we don't want to answer the default right question, we don't want to grant property, the question still persists. And probably, if we think this is a problem, we need to understand, we need to have some regulatory intervention. But before discussing what we should change, we should better understand what the law as it already exists today is. And on that, I'll give voice to Martim. Thank you for this. If you're interested in more details, I actually wrote a PhD about that. You can see it in open access. And with any questions and suggestions, I'm always happy to talk. Thank you very much.
Thank you so much, Przemysław, for your great presentation, your great talk. And now, Martim, you have the floor is yours. I don't know if you have a presentation or not.
Thank you. Thank you, Professor. Yes, I also have a PowerPoint presentation ready. Just going to share my screen. Exactly.
Great. You can.
Okay.
You can start then. Martim is a researcher at the Nova Consumer Lab. Please.
I'll start. So I'm going to pick up these subjects following the introduction that Przemysław gave. Namely, I'm going to focus on the existing regulation, how it can solve and answer some of the problems that arise from virtual goods. He already talked a lot about the unfair commercial practices and the Unfair Terms Directive. I'm just going to shortly revisit them, and also the Consumer Rights Directive, and then focus really on the novel Digital Content Directive, which gives some new solutions to the problems that were already pointed out, but still has some shortcomings. First of all, the European consumer law is basically a big web of directives and regulations, and this list is not exhaustive, which can be divided in both in substantive law and procedural law. It's good to keep this in mind to understand that we are talking about very different directives, and the fact that if we look at their dates, most of them they go back from an age where e-commerce wasn't the reality that it is today, and where the questions that we are making about digital goods and virtual goods within a subclass of digital goods weren't made back then, and so they weren't made with these concepts in mind and aren't fully prepared to answer most of the problems. So the unfair commercial practice is already touched upon very well. It's a directive that aims at stopping practices that distort and influence, misleads, or are aggressive against sets of consumers, especially those which are more vulnerable in nature due, for example, to age. It's a very prevalent problem in video games, which a lot of them are obviously consumed by children and early teens, which are not normally a very mature and well-aware demographic. Here is an example of those kind of more misleading tactics, namely the timers, the creation of scarcity that isn't really there, constantly giving pop-ups that this feature item is only available for one day. You have to really get on these daily offers. They are really great. You need to take advantage of this, and they are spams. The users and the players are constantly baited and notified about these offers, discounts. But these are just one of the most blatant examples of misleading practices. The most aggressive ones were the ones shown by Przemysław, namely the freemium modules, where the user starts playing the game and gets invested both in time and attached to the characters, to the story. He might have friends playing with them, and then paywalls start appearing, barriers to actually play the game, which can only be removed through the payments of real world money, which is also usually disguised through having to exchange that money first for the currency of the service. Now, there's also a very peculiar case, which is loot boxes. Loot boxes are basically you're paying a consideration, normally a currency, monetary value, or the virtual currency of the platform for usually a package, can be a box, can be a card pack, which gives the user a chance to earn a prize from the list of prizes, which have different values and different chances of coming up. This is very similar to gambling, and when there's secondary markets, it has been already identified in some jurisdictions to be gambling. The problem here is in the EU, we don't have an harmonized definition for gambling, and it depends very much on the cultural background of the member state in question. Going forward, the Inferior Directive, as Przemysław referred, is one of the general application directives on consumer law, which is most useful, especially when we are dealing with contracts like this. This is just a small section of a contract. They are normally very long. They are time-consuming to read. They don't use plain and intelligible language, and are difficult to decipher for non-jurists or lawyers, and in purpose. So, in the context of this directive, they already fail the formal requirements for these clauses to be enforced in court, or to be supposedly enforced in court, due to the consumers being already not fully understanding what they're actually subscribing to. Also, a lot of times the way these terms are presented are made in such a way that the consumer is incentivized to not read them and just go past them as fast as possible to get into the real good stuff, the game, the service itself. So they fail the formal requirements, and as Przemysław pointed out, they fail the material requirements. Namely, they create a power imbalance which cannot be argued it's rooted in good faith, especially when we're talking about the exclusion of all liability. The possibility of performing those kind of actions, like modifying or eliminating items from a player's account without having to notice them, without having to present a reason. A lot of times, when this happens in reality, aren't usually because the trader or the service provider is necessarily trying to punish a player out of I don't know, because it woke up badly that day. They're usually an effect of automated decision making that tries to pinpoint who is abusing the system in what way. But they don't have to give you a reason, and this list of reasons that appears here in the Pokemon Go terms and conditions is a non-exhaustive reason. So the consumers are, even if they go through these terms, they are never fully aware of the type of the behaviors they can't have without being susceptible to punishment, basically. Going forward, there's also a much more modern directive, the Consumers' Rights Directive from 2011, which created information duties for consumers and more transparency. It's especially applicable to distance contracts and off-premise contracts, and virtual goods are, in this context, distance contracts, and they should, so there are information requirements that should be met by the service provider, which usually, for example, the description of the functionalities of the virtual goods are usually just hidden in patch notes, very extensive patch notes about what came in that update, and they are not consulted by the majority of players. So they just see that normally the picture in a very short and enticing description, and they go for it without understanding really what they are supposedly acquiring or buying, as Przemysław stated. And arguably the biggest right given by this directive is the right of withdrawal, which, yes, it applies to virtual content, digital content actually, which could encompass virtual goods, but there's a loophole, a very simple loophole, which is through getting the player's consent, he can relinquish these rights. So it's in practice, it is what always happens. In the EULA, there's the consumers automatically relinquish and consent to not having these rights in relation to virtual goods. Finally, the Digital Content Directive. It's a directive that's trying to answer the fact that there wasn't regulation about several fundamental principles of consumer law about digital content and digital service, namely conformity, for example, just one of the most patent ones. It is very, its scope of application is very malleable because it applies to all contracts of supply, and it even considers personal data as a consideration. It has a broad definition of price. It has a very broad scope, but there's some shortcomings, namely two that I'm pointing out here. First of all, the restricted notion of consumer against the previous directive that I mentioned. The previous directive allowed for the protection of consumers and that are basically in dual purpose contracts, a contract both for private, the acquisition of a good or service that it's used for both private and professional commercial use, if the private use is predominant. Here we go, this doctrine of the predominant use is left out, and the only way you can still have protection as a consumer, according to the jurisprudence of the courts in relation to directives and conventions on procedural law, is if this contact with the professional activist is only marginal at best. And this basically leaves out consumer protection for esports players, streamers, YouTubers, journalists, video game journalists. So it might seem like a very niche demographic, but it's kind of still a considerable number of people that engage on these services, and they are left out of protection in a somewhat disproportional way. And another further problem arises, which is they may not be consumers on the cloud for the purpose of this directive in the context of the EULA, on the umbrella agreements to access the platform, but what if they acquire a virtual good that they never use when they are streaming or playing in a tournament or wherever, in the context of their professional activity? If they acquire a virtual goods solely for private use, shouldn't this contract be considered, shouldn't they be considered as acting as consumer for the purpose of this directive? It's an unanswered question. In addition to this problem, we have this directive is not applicable to gambling services, which is understandable, obviously. The EU legislator is trying to protect consumers which are acquiring legitimate digital services and goods, and it has and regulation of gambling is usually left out to the member states because of those cultural problems that I referred to. But loot boxes in several jurisdictions are starting to be considered as gambling. And if they are gambling, little John or Timmy, they spend 10 euros or 15 euros on loot boxes, and if they received, and if they open them and get virtual goods which don't correspond to the description of the functionality that, for example, it was the service provider gave for that specific virtual goods, or if they have more problems, they have problems, or if they are not, they were supposed to be supplied but they never arrived at the player's accounts. This directive and its remedies cannot be a safeguard for these people, basically. It was, in my opinion, this is the fault of this problem of loot boxes didn't even cross the EU legislature mind, and it's an accidental loophole. Now, without going extensively into the directive, we know, and I already referred to, that it deals with the supply of digital services and content. It gives new and improved criteria, namely subjective and objective for the conformity, and it also has a very good provision on the modifications on the service and content, not contractual modifications of the aspects of the way the content and service behaves, functions, operates with other services and contents. And in this case, the Article 19, it's modifications for the purpose not of maintaining conformity, of bringing something that is not in conformity back into the standards established by the contract itself, but discretionary modifications made by the service provider, which are not necessarily made in bad faith. They can be improvements made to the game. They don't have to be bad in nature. And the legislator considered that and phrased it very well. There's also the remedies for this service, for this directive, which we all know them. It's basically the same for goods. Now, the requirements for conformity, for the modifications to be made in good faith and be valid is, you need to have a clause that allows them. You need to have a valid reason to modify, and this needs to be on the clauses, on the terms of the contract. You can create additional costs for the consumer, and the consumer needs to be properly notified. And if you discretionarily modify virtual goods, you can have create the negative impacts on the consumer on the way they access and use those goods. And if this negative impact is more than minor, they have the right to terminate the contract. But several questions arise. What is a valid reason? What are the additional costs for the consumer? It's just a monetary cost on the in-game store, or they take the item away from me and I lose, and I need to pay to get it back. Is this an additional cost? Which contract can the consumer exercise the right to termination? The platform, or just the acquisition of the virtual goods? I argue that if he can only use it against the overall platform agreement, the contract to access the service, this is this is not useful for the consumer, because he wants to be on a platform, and he is, because of a problem with the specific virtual good, he is basically cutting himself off for the space that he wanted to access and stay in. Several scenarios arise, as Przemysław referred to. Game developers often need to balance and change the way virtual goods behave through balance patches and updates, sometimes improving some of them, sometimes decreasing the usability of the others. And this is assumed by the players. They know these things occur, and they are made as part of the sport. They make sense, but do they all make sense? Is this always a valid reason? And then the problem of enforcing codes of conduct, namely for punishing cheating, using bots to farm, for example, virtual goods, and the problem of harassments and abusive language, or usually problems that arise not just in video games but also on other digital services. So this is the end of my presentation, as there's some answers to some problems, others remain unanswered. I hope you enjoyed this presentation. I took a bit more than I planned to, a bit more time than I planned to. I hope you find this interesting, and both me and Przemysław are very open to questions and feedback and any ideas that also you can provide.
Thank you very much, Martim. And now our commentator today, as I have referred at the beginning of this talk, is Vanessa Mack, Professor of Civil Law at Leiden University. Thank you so much for being here, and now you can commentate on everything you want. Thank you.
Thank you, Jorge, and thanks to Przemysław and Martim for their wonderful presentations. I'm tempted to say that you've answered almost every problem, and so there's very little to discuss. But I'll try to pick up a few of the points that you made and see if we can perhaps address the bigger question, what should regulation of virtual goods look like in Europe? And so your explanation of the current regulation, Martim, sets a very good basis for further discussion in that respect. And let me comment, I'm copying the structure that Przemysław used, property contract, and perhaps other aspects of unfair commercial practices regulation. And let's have a look at then some specific points as to whether they could address the problems of virtual goods and the deletion by a platform. So first, property. And of course, you're right to say that these goods are intangible and that the provider has the power to delete them or modify them almost without influence from the user or consumer or player or whatever they are called in that context of gaming. I think you're right to point out the limitations of property law in this respect. So we're looking at something that is intangible, and in some ways, and this I relate this to the discussion of data and property law, perhaps contractual approaches are more suitable. We're looking at objects that can easily be copied or modified. So rather than tangible goods, perhaps contract law could be a better instrument to address what rights players or users have with regards to those goods. Having said that, I do want to put one example to you to say where property law could still be perhaps a more useful tool. And I'm thinking of a case that actually occurred in the Netherlands, where in the context of a game, a player won a certain prize, a prize shield, don't ask me what it looked like, and another player stole that from this player. So apparently that was possible within the setup of this game. The player who was robbed of this shield went to court and sued the gaming company for the value of this shield, and thought he sought to claim it back, so to revindicate this shield. And that's an action in property law, and of course it only works if the player can exercise property rights with respect to that particular item. The court actually went along with that argument and said that this is something of economic value, and it is an object within a game, but we treat it the same way as an object in the real world, and revindication should be possible. So I'm wondering, for that particular context, if you have thoughts on that. Is property law here a useful tool? And should other courts copy the Dutch court, or should we move to contract? And that's the second point, then contract law. I think you've shown in some ways already that contract law is a better instrument because it really goes to the rights that users have vis-a-vis the provider. At the same time, you've also shown the limitations in your presentation. So I think both of you addressed the possibility for consumers to invoke the Unfair Contract Terms Directive. But of course, that also has limitations. And one can wonder in this context whether it is sufficient to have that protection. I'll come to that in a second. That is the more structural point about imbalances in the digital economy and whether contractual protection is sufficient, seeing that then individual consumers will have to bring an action against a provider. But I'll come to that point. Just wanted to address the point of gambling as well that Martim raised. I think you're very right to point out that many of these examples also are closely connected to gambling law. And so there's these in-app purchases where I noted that on your example slide, it said these items are cosmetic only and do not give a competitive advantage. I wonder if that's also some sort of expression of the provider to say, look, this is not related to gambling law. And gambling law is a field in itself, and it is less harmonized, so that creates problems if you look across the EU member states. So maybe two questions. One, should there be more of a lobby for harmonizing gambling law in relation to these virtual goods? Since we see that this is perhaps in games and apps a more important element that is currently not addressed. So if we ask what the law should look like, should that be a focus? And second, what is the relation between gambling law and consumer law? And it is my impression that they are sometimes artificially separated simply because they developed separately and because the gambling industry is dominated by very powerful operators who, well, I think you're right to say there are cultural differences between member states, but also those operators lobby and are often successful in preventing regulation to come into being. So yeah, so that point, should consumer law and gambling law be integrated more? And then of course the question how, but we can maybe leave that to the European legislator. Then my final point, so if we look at these different instruments to address consumer protection in relation to virtual goods, we see property law, contract law, and their limitations. It brings me back to the point that Przemek made in his presentation at the very end, where he said there is a structural imbalance between the rights of users and providers. In another context, I've heard Nathalie Helberger and Hans Miklitz refer to this as a digital asymmetry. And that captures this idea of big tech companies knowing much more about their customers than the other way around, and actually actively seeking out vulnerabilities in order to make profit. And that you could say it's the same here. So those in-app purchases are addictive and users are tempted to buy them. And companies have very neat ways of tempting their customers and are getting better at it simply because they have the data on the behavior of these customers. So if we look at this digital asymmetry, then are solutions in property and contract law sufficient? Or should we also look at regulation that can well, address the markets on a broader scale? And then you can think of the Unfair Commercial Practices Directive, so extend its protection also to those cases where goods can be deleted unilaterally by a provider. Perhaps also competition law has a role to play there, especially when companies have large sets of data that allow them to predict the behavior of their customers. And there may be other forms of regulation that I'm overlooking here, but we only have a little time for discussion, so I think this is already enough. I hope this gives some input for the discussion, and thank you again for your presentations.
Thank you very much, Vanessa. Who wants to start answering these such an interesting questions? Przemysław, do you want to?
Yeah, maybe I'll go first. So I'll leave the question of gambling to Martin, but thank you so much, Vanessa. Those are all wonderful points and definitely something to take into account when developing this further. When it comes to property, it is indeed a very interesting case. The Dutch case is one of the few that we have in the EU on that. The difference there, I think, is that it considered the relationship between a player and another player, and not between the player and the service provider. So we didn't get into these questions here, but also sort of responsibilities of service provider when it comes to these relations are very interesting. And of course, you're right that there is a role to play for property law if we think about it, not maybe in the essentialist way in which we think about it often in the EU, but more the ways Americans do it, which is, it's a bundle of sticks. There is really a lot of various small rights that we could be granting to consumers. So maybe this type of intervention is wise. I didn't really get into details of that, but you're right, and it's probably something I should pay more attention to. And then when it comes to the digital asymmetry, it is a fascinating question, and I actually really like this idea of Hans and Natalie. I think there are sort of two separate problems here, though. One is the ability to abuse the vulnerability of the consumer, and what I like about Hans and Natalie's idea is that we sort of should change the way we understand vulnerability from the way it is now, which is as a property, as a static property of a particular consumer, where someone who's, for example, old or a child, or for whatever reason, generally is vulnerable, whereas we, I suppose, for the purposes of that directive are not, to rather a dynamic state in which every consumer every now and then finds themselves, right? So maybe when I wake up in the morning, I am vulnerable to buy something, whereas when I'm fine throughout the day, I'm not. So that's definitely something to consider. When it comes to the unfair commercial practices, maybe sort of forcing companies to change the phrasing of those purchases is where this can come in, right? Like, don't call it a shop, don't call it a purchase. Just say, hey, it's a license, but make it clear already at the moment of buying that it might be deleted. But these two are still, I think, separate from the question of deleting or modifying items, even if the consumer is not vulnerable, and even when it was clear, right? Maybe we do need some limitations on the usage of sort of digital force or algorithmic force. And as Martim alluded to the regulation in the Digital Content Directive, maybe that's a good start, but we sort of need to think more broadly about, on one hand, the subjective scope, whether it should apply only to these thinly defined consumers, and also explain better exactly what the reasonable reason is, what a loss is. So that would be my answer. But yeah, thank you so much for taking time and engaging with this. It's extremely helpful, and I really enjoyed it.
Martim.
Thank you. Thank you for all your questions, Vanessa. They were very interesting, and I'm still thinking about them and how to tackle some of them. The first question that Przemysław already answered, I also have some thoughts on it. I find it interesting that, and kind of denouncing that the fact that that player that lost the shield, whether it was criminally stolen or using an exploit of a game, that for the context, he lost access because of an action of another player, but he didn't place he didn't go to court against the other player. He went against the service provider. In the idea, I think that it was the service provider that failed in its obligations to supply the virtual code in this instance. It might be because of an action of a third party, but here the Yale and the umbrella agreement can still be used by the player to enforce this right, at least to a kind of digital possession or access to a given virtual goods. And it is sticking solely to civil private law. If we go to criminal law, if, for example, there is a secondary, the idea there is a secondary market sometimes for the exchange of these items between players, we could recognize that these kind of possession or right of access, or right of use of the digital good has a monetary value, and there was a damage caused by that for the party, that player, and maybe here the criminal proceedings could be placed against him and not necessarily against the service provider. In relation to the question of gambling, the biggest problem that I've seen when reading about this topic is that even without considering all of the gambling regulations on the matter of who should be able to gamble, how should the authorization schemes operate, should this be a monopoly of the state, the biggest problem is what is gambling itself, the definition, because in the European Union there's a myriad of different ways to interpret and consider what are games of chance, games of chance for the purpose of gambling. Sometimes even between very very culturally close or like-minded member states. The cases that I referred or alluded more likely about the crackdown on loot boxes were the Netherlands and Belgium, and they launched investigations, the administrative authorities, and they took different conclusions, and they gave different fines to different companies based on a different definition of gambling. I think this was Netherlands, that their preoccupation was the fact that because in some video games you could exchange those items on the secondary market, so they were like tokens on a casino, and this was gambling. Belgium did not thought that it was necessary to have the ability to exchange those virtual goods for real money or for other virtual goods with other players. Just the idea that the person itself attributes or gives a subjective value to the possession of those goods, and that this is gambling. This is a prize, not necessarily on the economic sense, but on a subjective sense, the player received the prize. So even in games where you can't have a secondary market, Belgium find those companies, while Netherlands did not. So these are really close countries with very similar cultures, and there was this huge disparity, and it's very problematic. The gambling, the lobbies obviously aren't very interested on expanding regulation, especially when it leads to crackdowns. And I think it's very denouncing that in your EU consumer directives and law in general, when a certain directive is not applicable to gambling law, it gives always a very short and naked, very as bare bones as possible definition of gambling, and then it leaves to the member states on transposition to better interpret this limitation on the scope of the provision itself. And so I would welcome very much an effort to harmonize the definition of gambling and gambling services, but I'm a bit skeptic on it ever happening, especially soon. I think it should, especially for this case of virtual goods, not just because in some instances the player should be protected, even if they acquired through loot boxes, they could be identified as being gambling. But in general, the authorization schemes and ensuring that children aren't throwing away large amounts of money and acting as whales, as Przemysław are referred in these misleading and aggressive commercial practices. Was there any other question that you raised besides these two?
I think you already answered
Yeah, I already gave my thoughts. I'm sorry. I was trying to think if I missed anything.
Thank you so much, Martim. Vanessa, don't know if you want to add something or.
I'm very happy with the answers, and there's indeed a lot more to think about. But looking at the time, perhaps you want to give other people the opportunity to ask a question.
So does anyone want to ask something or comment on something?
Yeah, can I ask Martin a question?
Yes, of course, Tomas. Welcome also to this.
I'll turn on the camera just so it
Great.
doesn't seem that.
Thank you.
Okay, so well, I'm sure that Martin is aware of the Csgo Lalo scandal that happened a couple of years back. That involved gambling and minors and the whole loot box scenario. And I believe it ended with a settlement between the people who ran the website and the victims, in the sense that I think it was a settlement, so it wasn't necessarily a conviction, and it was in the U.S. It was by the Federal Trade Commission, and because the people who ran the website were these famous YouTubers and these famous gamers, they were able to attract these children to their website, the website that they controlled and that they owned, and that they can manipulate the results and the outcomes of the biddings. So I just like to ask: is there any sort of mechanism to prevent such a situation from happening in the EU? And if there's any way victims of situations like this could possibly redeem anything from the abusers?
Thanks a lot for that question, Tomas. It's really interesting. In that case, in particular, giving a few more facts, those famous YouTubers that they made some videos promoting the gambling website, where you gambled with the virtual goods itself. It wasn't with real money, but you threw them in a pot and you won the pot in a randomized way. You got all the virtual goods from the people that were participating. They didn't told anyone in their videos, and in the website there wasn't any information, but they were actually the owners of the website. So they were like promoting that as a look at this thing that I'm not in any way related to. And then there was that problem that in their videos, they earn a lot of virtual goods. They have some losses, but overall, they always hit the jackpot, and it's very dramatic. And so, yeah, they manipulated the results to promote the website. I think the problem here would be solved through not just gambling law, but through the Unfair Commercial Practices Directive, with all the misleading they took to. And I've lost the internet. Is my connection back? Yeah.
Yes, you are here. You are here. We never lost you.
So it would be probably in the field of consumer law through those type of mechanisms. From the fact that there was a lot of misleading. There's also a lot, but I'm not versed into, is advertisement regulation and marketing regulation, especially when it's concerning to gambling services. There's requirements for transparency to understand who is the owner, the transparency on the chances of and also the problem, which is directly marketing gambling services to children, which was the case. They were aware that the majority of their audience were children by the analytics provided by, in this case, if I'm not mistaken, YouTube itself. I don't have a full question about a full answer for you, Tomas. I think there's several ways, and it varies a lot between member states, but there would be the victims wouldn't be left without remedies and solutions in those instances, and there's probably liability, a huge liability from those schemers. I don't know what other way to call them, crooks there.
Thank you.
Thank you, Martin. Przemysław, do you want to say something about this? No, thank you so much. Unfortunately, we are out of time. The idea is to finish these talks after 1 hour. It was a great pleasure to have you here. I'm also seeing Bilge, who turned her camera on. Hi. Thank you so much again.
Hi.
Hi. Vanessa and Przemysław and Martim and Nezea, who is here now. I can see now also.
Yes, thank you for this interesting conversation.
Thank you so much, and see you soon. I hope all of you. It was really a pleasure to have and host this talk here via Zoom, but at Nova School of Law. Thank you so much.
Thanks, Lalo. It was great.
Thank you.
Thank you.
Thank you.
Thank you.
It was great.
Thank you. Bye bye.
Thank you. Bye. Thank you.
Bye.